Good afternoon, everyone. Thank you for joining us today. And we're going to be the host today. And this is our first NJIT Data Science Stars Seminar Series. And we're going to have Professor David Opderbeck from actually he is the professor of law and co-director of the Gibbons Institute of Law, Science and Technology and also Institute for Privacy Protection at Seton Hall University Law School. And his legal scholarship focuses on artificial intelligence, cyber security, data privacy, and intellectual property law. He develops and teaches cybersecurity, data privacy. Uh, sorry. He develops and teaches innovative courses in technology law, including cybersecurity law and policy, artificial intelligence and the law, and the data privacy and security lab. He also leads the law school's data privacy and security compliance program. In core law school curriculum, he has taught property law, constitutional law, and torts. He's also faculty associate with the Berkman Klein Center for Internet and Society at Harvard University. Prior to his career in academia, Professor Opderbeck was a partner in the intellectual property technology practice at McCarter English Company, where he began practicing cyber and intellectual property law in the early years of the public internet. Let's join me in welcoming Professor David Opderbeck, and the floor is yours.
Thank you. Thank you. Well, it's great to see you all. It's great to see a good filled room today, and I'm really excited to be joining you here. Some of you probably know Seton Hall Law is right, kind of just a few blocks away here in Newark. So it's wonderful to be back and to be doing some things here at NJIT. And my talk, and I think the format for what we're doing is I'll talk for a bit, 25 minutes or so with this presentation, and then we're going to kind of move to a sort of Q&A format. But I want to talk to you today about developing legal frameworks for artificial intelligence. And as was mentioned, I started practicing law in the early 90s when the public internet was really a very, very new thing. I think I'm looking around the room, I don't think anyone here probably remembers this, right? But 1994 or so was when the internet really began to become commercialized. And we were wrestling with questions back then about what is actually the nature of this new technology, and how are the kind of frameworks of the law that we have going to map onto or not map onto this new technology. And now we're really going through the same thing with AI. I very much feel like it's a very similar kind of dynamic because we have a new technology. We know it's already becoming transformative. We're just at the beginning of seeing what it's doing, and we're just at the beginning of kind of on the law and policy side of thinking about what some of its benefits are as well as some of its risks, and how and if in what way the law needs to step in and do something about that. All right, so the first thing I want to do is just talk about a bit about how on the law and policy side we're thinking about some of the potential risks of AI. And when we talk about some of these risks, and then we talk about some kind of ethical frameworks, general kind of ethical and governance frameworks that are being developed relating to what we see as those risks. And then from those general kind of ethical frameworks, we look at how the law is trying to kind of incorporate some of those ethical ideas into the way the law governs things. And we think about law, we don't necessarily want to sort of encode every moral or ethical value into law, but we do want to say that our legal principles relate to some kind of broader principles. So this is just one way of doing this, and I'll send the slides around so you can all have them when we're done. And there are different ways that people will map these things, but you'll find that they all tend to converge around some common themes. So one area of risk is what the authors of this particular study call representational, right? And one of the interesting things that we found, sort of looking socially at the way AI is being used and the way people think about it, there's kind of almost this default setting that people have to think, you know, a computer is doing this, a machine is doing this, AI is doing this. You know, it's not going to have the biases that a human being might have. And as we all know, that's just not true at all, right? Because the machines are trained on human data. The machines are created by human beings. And so we're very concerned about how the machines might stereotype people based on what we call in the law protective classes. So, you know, race or gender or sexual orientation or other things, religion, other things like that. So we're worried about those kinds of things. And in any given AI system, this could be intentional, but very often it's not intentional at all. It's just, you know, sort of an artifact of what's in the training data, or it's just sort of how the system is being used and what it's learning as it's being used, but it's something we have to be aware of. Allocative. Oh, sorry, hey, I thought you had a question up your video. And I can take questions if you want as we go along, but we'll also have some time at the end. So allocative, you know, this is a resource, right? It's a strategic resource, it's an economic resource, it's an opportunity resource. So who's going to have access to this resource? Who's going to be able to use it? Who's going to be able to benefit from it? And then also, who's going to be harmed by it? Like, what jobs are going to go away because of AI? What jobs are going to be created? What jobs are going to go away? What jobs are going to change? We were talking at lunch a little bit about some of the ways AI is being used in different professions, and I was talking about as a lawyer, for example. And when I first started practicing law, you know, one of my jobs as a junior lawyer was to take volumes of testimony from court cases and with a dictaphone, literally summarize them so that other people who are working on the cases didn't have to read 1,000 pages, they could read, you know, 10 pages. Well, you don't need a junior lawyer to do that anymore, right? We actually haven't for quite a while, but it's even better, even, you know, more efficient. So what jobs are going away, but what jobs are being created? We talk about quality of service. And here we're asking, you know, what kind of services is the AI actually providing? Is it actually good, right? I talked about, you know, summarizing testimony, for example. Now, when I was a more senior lawyer and I was supervising junior lawyers, I had junior lawyers summarizing testimony for me. But I still have a responsibility to my client and to the court to make sure that that job was done right, right? So I have to supervise that job. Now, if I have to just redo the whole job, that's not very helpful. So what I have to do is, you know, train some people that I can rely on, find ways to sort of audit and spot check, right? All those same kinds of things now we have to think about with AI. And then interpersonal. So in what way is AI going to affect our well-being as people who relate to each other? In what way is AI going to affect things like our privacy, for example? You know, we were talking a bit again before about using AI to sort of see patterns in data, say in a city. Very useful to know, okay, so where are certain crimes happening? Where is there economic opportunity happening? Things like that, right? But when we think of all that, it's a kind of surveillance. Now, if we want to have some kind of security, we've got to have some kind of surveillance. But we have to balance that with our civil liberties, right? So how do we do that when we're using a really powerful machine? And then social systems. And so we're really talking here about kind of, at one side, kind of governance. So what sorts of decisions is a machine, is an AI going to be making? Another thing we talked about at lunch is the use of AI in judicial decision making. So right now, for example, you know, there are AI systems being used in sentencing decisions in court. So if someone's convicted of a crime, then there's some range in which, you know, a judge will say, you get probation, you go to jail, anything, you know, different things in between. And there's a range of factors that the court has to look at. There's all the facts in the case, and so a human judge has to do all that. Well, an AI is pretty good at that. Pretty good looking at a matrix of information like that and historical patterns and making a recommendation. That could be really helpful. On the other hand, it raises a lot of questions for us. Is this how the law works? Don't we want a human judge stepping in? Are there going to be biases? Those sorts of things. And then another thing I'll point out in this one that people are just really beginning to talk about is the environmental impacts of AI. So as we know, right, to really do a sophisticated AI system takes a lot of compute power, and that compute power takes a lot of energy, and that energy has a big impact on the environment. And so how are we thinking about those sorts of things? All of these domains are kind of ethical domains that then policy is going to begin to interact with. All right, so we have seen, based on these kind of concerns, different statements of kind of values or AI ethics. And again, there's a bunch of different ones. They all are worded a little bit differently, but they converge on common themes. This one happens to be from the OECD, which is a European kind of agency, right? And I'll just put them all up here and we can talk through them. So in general, people talking about AI ethics are saying, well, we want it to be inclusive. We're worried about the allocative effects. We want to make sure that the most possible people, right, get the most possible benefit. We want to make sure that people who are left out have sort of other ways to sort of come back in, right, with AI. We want it to be sustainable. We want to make sure we're human-centric. You read any statement on AI ethics, and it will always emphasize this theme of human centricity. Now, when we think of AI, in popular culture at least, probably not you all in this room, but in popular culture, people think AI, they think, Terminator, they think that self-aware, intelligent machine that's taking over the world, right? They think of the singularity of AI. But we know technologically, if that's even possible, it's probably not likely in the near term, right? We want to think about that for law and policy in the event that it's possible. That's not exactly what we're dealing with now. But we still want to say, how is it that human beings remain the center of what we're doing? How is it that human beings remain what is actually governing and overseeing what we're doing? Transparency and explainability. This becomes a really big one, and we'll see when I show you some of the legal rules that are being developed. AI has this problem very often. You've heard it referred to, I'm sure, as the black box problem, right? Sometimes it really is a black box, sometimes it isn't. But it can become difficult to know, how is this thing making this decision, right? It's come out with a decision. How can I trace sort of the steps that it's gone through or the way that it's made this decision? How can I explain to someone why this result has particularly come out? For the law, historically, traditionally, when we think about jurisprudence as the idea of what the law means, right? Traditionally, we say the ability of an ordinary person to understand what decisions were made is really important to the legitimacy of the law, right? If I'm governed by the law, not just by arbitrary power, that means, and you're saying, well, look, you have to pay a fine. It's not just you're saying that, you have the gun, so I have to pay the fine. It's you can give me reasons, and I can understand, all right, XYZ happened, the law says ABC, I have to pay the fine, right? So how do we do that when a system is making decisions? So transparency, explainability, robustness, security, and safety. We were also talking before about self-driving cars, for example. One of your professors was talking about his Tesla, right? And using that mode and sort of going in and out of the traffic. Well, great. How do we know that's safe and secure? What does the law do in the event there's an accident? And whose fault is that? And how does the law incentivize, right? We know how that works from many years of experience with just human drivers driving a car. We have negligence law, and it deals with that, right? So now how do we do that with AI? And then security in terms of cybersecurity as well. I would say, I've been teaching cybersecurity law for about a decade now, and when I started teaching it, it was a new thing. And it was all about, data loss, data theft, ransomware, things like that. And it still is a lot about that in that course. But we now have a pretty well-defined pathway to say, here are security protocols that are reasonable for, say, a company to follow. Here's when we have a feel that they didn't follow those and maybe there's some liability, right? Things like that. And we're just beginning to learn how that works with many AI systems. So, for example, adversarial prompting. You're trying to break the machine. You're trying to find out maybe the intellectual property under the machine. Or you're just trying to make it do something that it's not supposed to do, right? That it's not put out there to do. What do we do with that as a security concern? And then accountability. So the law is all about accountability. So take, again, the common example of just an ordinary auto accident. You're driving down the street, someone hits you, you're at the stoplight, someone rear-ends your car, and you hurt your neck. Right? Basic, common kind of case. So we know then, all right, you've been injured, you're incurring a cost, you've lost work, you have medical bills, the law will hold that other driver accountable. They'll have to pay damages, and they will have insurance, right? And the insurance will pay, and we spread that risk. Relatively simple in that kind of case. Take something a little more difficult, a lot more difficult, like take a medicine that you might take, right? A pharmaceutical drug. It's been approved by the government, but it has some side effects. And it happens that you are really affected by some of those side effects, and you get seriously ill. And that gets traced to the effect of that drug. Well, who's responsible? The government approved it. It had a special side effect. Your doctor may or may not have noticed all of that. It's a difficult case, but it's a kind of case we've been dealing with in the law for 30 or 40 years or 50 years. And so we kind of know how to do it, right? We sort of know what happens. What do we do with an AI technology stack? Like, let's take that self-driving car again. It's actually a little easier with Tesla because from my understanding, they sort of keep pretty much the whole technology stack in-house, right? But take an AI system that has been developed on an open platform, and you've got multiple contributors to that open platform. Some of it's open source, some of it's closed source. Then you've got someone else who has taken that and bundled it into another product. So you've got multiple developers, some contractors, some other people there. And then you've got that's being put into a user interface that's being designed in a certain way for a certain use, and that has been subject to additional specialized training for that special use. Start to multiply that. I have a talk I do specifically on liability and product liability in AI where I sort of explode a technology stack. But think of the complexity of all of those players. And who's responsible? How do we even figure that out? Difficult question in the law. All right, so that's accountability. But we want to have accountability because what we want to do in society, what the law wants to do, what the ethics want to do, is we want to spread risk. We don't want any one person who suffers an injury to have to bear the whole cost of that injury most of the time. Most of the time, we say, we want a system that spreads liability, people have insurance, products have insurance, so not any one person. We actually all, in a way, kind of bear some of that risk. All right, so that's kind of AI risks, AI ethics, and now let's talk about some possible regulatory models, and then we'll talk about some details of some of the law. All right, so regulatory models. There's really two main approaches that we could take if we're thinking of the government regulating something like AI. One is comprehensive. So we could say, let's have basically one law, an AI law, right? That law will apply no matter what industry you're in. Healthcare, automobiles, government, whatever it is, that one law applies. Or we could have a sectorial model, which says, no, actually, I'm going to have special laws that apply in each different domain. If you're in healthcare, there's healthcare laws, and they might have an AI component. We could do either one of those or some mix of those. And what I would say now with AI is it's very similar to the way data privacy law has developed over the past maybe 8 years, 8 to 10 years, right? So data privacy, and it's kind of divided in different parts of the world. So if we think of data privacy law, in the EU, the European Union was the first mover in data privacy. Adopted the GDPR, the General Data Protection Regulation, which is a comprehensive law, applies across all the different sectors, and they were the first mover in doing that. The U.S. has not taken that approach. The U.S. approach to privacy, really since the 70s, but up until now, has been sectorial. So in the healthcare arena, we have a law called HIPAA, which actually relates to insurance, believe it or not, but it's your health data in the U.S., you have privacy because of HIPAA. In banking, we have something called GLIBA, so it's a special banking law. Right, so in different areas, education, we have FERPA, you might be aware of as students. Your educational records, you have privacy rights in FERPA. But in all these different domains, it's just a different way of doing it. That's what the U.S. has done. Now, we have seen in privacy in the U.S. that some of the states within the U.S. have been adopting comprehensive laws that are in privacy that are mirrored on the GDPR. California was one of the first, and now there's about 20 or 30 states. This is an interesting feature of the way the U.S. politically is set up, right? We have our federal government, and then each state government is also its own sovereign and can do some of its own things in relation to the federal government. So this is what we're seeing in data privacy. We're pretty much seeing a very similar dynamic right now in AI. So what we have in AI in terms of actual hard law, we have in the EU an AI Act, which I'm going to show you some features of in just a minute. That is a comprehensive law across the EU, and that actually spills out beyond the borders of the EU. And then in the US, we do not have any federal comprehensive law. We have some policy. I'll show you that in just a moment. And some of the US states are adopting specific laws about AI. So a very similar dynamic for a bunch of different reasons. So I'll just talk for a second here about at the federal government level in the US on AI. And as I mentioned, we don't have a comprehensive law. In fact, we really don't have any federal law governing AI in the US in terms of those criteria that I mentioned, accountability, those sorts of things, right? We had some policy documents, and this is a really interesting dynamic. I'm not totally sure what to make of it myself, but the previous presidential administration, the Biden administration, had issued an order on ensuring safe AI. So you really have to get into the weeds a bit, which we won't do here, on what this kind of document is. It basically is governing the federal government. It doesn't do much in terms of how you and I operate, but it sets some policies. The basic idea was, let's come up with some safety guidelines. Let's do something about critical infrastructure like, power plants and things like that. Let's evaluate things like deep fakes and how we might identify those. It had one thing about what they call dual-use foundation models. If you dug into that definition, basically it was based on compute power, and that definition basically was whatever the next generation of ChatGPT is, that's what it would cover, right? So it was one thing. So it was pretty modest. Interestingly enough, when the Trump administration, now the second Trump administration, that first day when the president issued a whole bunch of executive orders on a whole bunch of different things, rescinded this order, so revoked this order. It wasn't entirely clear why. And then shortly after that, the administration announced this government funding for a big infrastructure project with Sam Altman and Larry Ellison, right, and SoftBank. So I honestly don't know what to make of all this. OpenAI has talked about some of this. Elon Musk is very critical of this. As you know, he's fighting now with Sam Altman, probably if you're watching the news on all this, right? So who knows? I mean, the Trump administration might come out with its own version of something like the Biden order, or there might be more going on here, I'm not sure, right? Just not much happening at the federal level. At the state and local level in the US, right, we've got some places, both cities and states, adopting some very specific kinds of things. So these are just a couple of examples. These are popping up like, you know, every week or so, there's another one of these that pops up. So New York City has a law about, you know, AI and job screening. You probably are all painfully aware of this at this point in your lives, but you know, you put in your resume is being scanned screened by AI, right? So in New York, you have to have notice of that, and they're supposed to go through some kind of audit to make sure it's fair. Not clear to me what that audit actually covers. California has something where, you know, if you're interacting with a chat bot, like a customer service bot or something that's AI powered, you're supposed to be notified of that. So just little things like that popping up here and there at the state level in the US. So the big action in the law and hard law, when I say hard law, I mean like, you know, legislative rules or court rules that have been adopted that require an AI producer or developer or deployer to do something or not do something, right? So I'm just going to give you in the next 5 to 10 minutes just some of the outlines of the EU AI Act, so you get a feel for what the EU is doing. And you know, I'll say that people who are looking in the law and policy space about AI have mixed feelings about the EU AI Act, as I do. A lot of it seems really positive and really useful. Some of it seems maybe too aggressive in terms of regulation. You know, it's not clear how it will affect innovation, because you're always trying to balance. We don't want to crush the innovation of the technology. We want to govern it, right? Some of it is just who knows, because it's vague. I think a lot of it is that. All right, so basic things, and again, I'll just kind of put all this up here. So there are some things that the EU AI Act just flat out prohibits, and I'm going to go through the list and show you what some of these things are. So some things the EU says, look, you can't do that. You can't use AI for that purpose, right? There are some kinds of AI applications that the EU defines as high risk. I'll show you what that definition refers to. It covers a lot of things. And if it's high risk, there are some sort of heightened standards of requirements for what you have to do to test it and to show that it's safe, right? There are also requirements for what the regulation calls general purpose AI. I'll show you that definition. You'll see it's getting at large language models and things of that sort, right? So a couple of different buckets. The degree of regulation varies a little bit. Some things prohibited. Puts obligations on providers and deployers. When the definitions are real legalese, but what they're talking about, if you are developing an AI system, you're a provider. If you're implementing it, you're a deployer, right? So if somebody's making an AI system to screen job applicants, they're a provider. If you're the company that's using it, you know, you're a deployer, right? So they all have obligations. Applies to any AI used in the EU. So like the GDPR, and this is another kind of interesting legal question, when we think of law in the modern era, and we'll set aside international law for a minute, right? This is national law. The law applies within the territory that it applies to, right? So U.S. law, U.S. federal law, it applies in the United States. If you know, you're in France, generally speaking, you're not subject to U.S. law, right? You're subject to French law. That just makes sense. It's a territorial thing. That is true of the GDPR, the privacy law, and of the AI Act, but it applies to any interaction with an EU person. So if you are deploying an AI system in the US, but you have European customers, for example, this is going to apply to you, just like GDPR does. So it has a much broader reach than just the territorial boundaries of the EU. It will establish an EU-level authority. So there will be a governmental agency in the EU as a whole governing AI, and then in each of the member nations of the EU. The EU is basically a treaty that connects the European nations together, right? So a governmental level authority, There will be fines if you don't comply. And it was signed in August 2024, but it gets rolled out over time. So all of us in the field who are working with, lawyers working with clients, for example, in this space, are aware of all this timeline, and our people are now working with clients to say, well, how do we get ready and get compliant so that if we get audited at some point, right, we won't run into a problem. One of the really difficult things of the law in this space is defining what we're even talking about. And I'm sure if I asked you to give me a definition of AI, I would probably get 20 different variations on a definition, because we're not even clear what we mean when we say that now. The definition in the AI Act focuses on this idea of inference, which I just think is really interesting and to me kind of problematic. And this is sort of just me philosophically, because I do some philosophy work on this stuff too. Like, I don't think AI infers. I don't think it's conscious. Certainly not the current iterations of it, right? So whatever it's doing, I'm a little troubled by anthropomorphizing it, but that's what the EU AI Act does. I'm not sure what this means. I think they know, they have an idea of what it means, but so that's interesting. GPAI, as I said, general purpose. If you look at these pieces of this definition, I won't read all of this, right? But it's generally usable, right? So something like a large language model, that's a general model, and then I can tweak this. I can make it specific to writing legal briefs or to writing technical papers or whatever. It could be GPAI. All right, prohibited practices. I won't read all these, but I'm just going to go through them quick, and you'll get a feel for them, right? So some of these, I think you can see how these map onto those ethical categories we talked about, right? So exploiting vulnerabilities of age or disability, social scoring, certain kinds of activity the government might do, like criminal profiling. So you can see how some of those, might make sense, or biometric information to deduce membership of a certain class. So using biometrics to say this person is that race, right? Or this person is that sexual orientation or whatever, which AI can do, right? Facial recognition and other things can do. So those sorts of things are prohibited. Some of these that are a little ambiguous to me and really interesting. This first one, right? Subliminally, purposefully manipulating techniques with the effect of materially distorting behavior. That sounds to me like any online advertising you can think of. Right? It sounds to me like your TikTok feed. But that's not what it means, I don't think. So I'm not sure, right? It's hard to find a definition of what some of these things mean. You have some other little interesting things, like creating facial recognition through untargeted scraping from the internet or CCTV footage. Why is that in there? Well, it's in there because some of the first generations of really powerful facial recognition technology were built on training data sets that were scraped from Flickr and other photo sharing sites, where the original users were giving a Creative Commons license, but they didn't have any idea that it was going to be used for AI training. Right? So certain categories of things banned, and then the general requirements. Right? So for general purpose AI, we have requirements for transparency. So you have to disclose to the user that they're interacting with an AI system. Then you have things like risk assessments and documentation and things like that. And then the high-risk systems, right? So then this category of things that are considered high risk. The way the EU AI Act is doing this is it's referring to certain categories of activities, right? So biometrics, critical infrastructure, education, employment, access to government services like security, social security benefits, things like that, the equivalent of that in Europe. Law enforcement activities, immigration, justice activities. This is if you look at this list, pretty broad range of things in the general economy. Pretty broad range of things that AI is being used really effectively for right now, right? So all of these things, it's not banned, but it's just subject to these general requirements of transparency and notice, but also some higher requirements. So what are those higher requirements? It's basically a risk management framework. And this is very much I think, playing off of privacy and cybersecurity. Right? So the GDPR, the privacy regulation, is in large part a risk management framework. It's not saying that you can't use someone's personal information, right? Period. There are some things you can't use it for, but generally, if you're doing a transaction with someone's just coming into your shop and buying a bottle of water, and you take their credit card information, you're collecting personal information. That's fine. You just have to have a risk management framework for how you're storing that, for when you delete it, for how you're securing access to it, things like that, right? So similar idea with high-risk AI. Yes, you can use biometrics outside of the category that's banned, right? You can't use biometrics to racially profile, but you could use biometrics, for example, to say, okay, this person has come into my casino 5 times in the last month, or a repeat visitor, right? So now I know facial recognition has identified them. I'm gonna dispatch a host to make sure they're comfortable and they're a repeat customer, right? Something like that. Sure, you could use it for that, but we have to have this risk management around it, and the risk management framework is just really kind of a balancing sort of test. And what it requires the deployer and the producer of the AI system to do is to really go through the exercise at the beginning of creating the system. So it's a by design idea, right? At the beginning of creating the system, of thinking through these issues, and then of documenting what they've done. So now, if we do have a problem at some point, well, then we can say, did you take the right steps? Then you, as the developer or deployer, can say, yes, we did, or if you didn't, you can deal with that. All right, so data governance. So there are requirements which at this point are pretty unspecified. So this is going to have to be fleshed out through further regulation. But what is good training data, right? What are good training practices? How do we validate that when something has been trained, it's doing what we expect it to do? How do we audit the way something develops and figure out if it's gone wrong, why it's gone wrong, right? Documenting those sort of things. Data security. And then this one is really crucial, human oversight. So what this one requires is that at every step of creating an AI system, of deploying the AI system, and then of the user using it, there must be a human being in the loop. So we talk about a human in the loop, right? And so the human in the loop has to be able to do a bunch of different things. They have to be able to know what decisions the system is making. They have to be able to know why it's reached those decisions. They have to be able to intervene. They have to be able to turn the system off, and then they have to be able to override a decision made by the system. So that's a pretty robust set of requirements for a human being to be in the loop and to be reviewing what an AI system is doing. Okay, so before we have our sort of fireside chat piece of this, this is where we are. There's a robust framework in the EU, but none of it is fleshed out. We don't really know how it's all going to work. We don't know. There's a lot of people suggesting that some of those categories of prohibited acts are too vague and they might unduly burden innovation. We are still deciding, Europe has decided on this comprehensive approach, the US hasn't. So which way are we going to go? Setting aside politics and whether it's possible to get anything done, if we could get something done, which way would we go? Whenever we're thinking about regulation like this, we're wondering, do we see that there's risks and dangers and maybe we want to be more aggressive with our regulation? Or do we see that the technology do we see that the technology has all this promise, we don't want to regulate too much? How do we do that? Like, how do we balance those things out? And then I'm going to mention 2 things that I only really, really briefly touched on in this whole discussion because they don't really come up with this public law that we're talking about, this kind of government law we're talking about. So in policymaking, what is the role of these large platform companies? I'm very concerned about this. To me, I'll be honest, the whole saga of the Biden executive order getting repealed and then right after that, this big venture involving Sam Altman and SoftBank, that does not pass the sniff test with me, right? But we know regardless of that, and we've known for decades now in the internet context with social media and the cloud, we've got basically 5 big companies that dominate that space. Google, Apple, Microsoft, Meta, and Amazon, the GAMAM companies. It's not exactly that same list of companies. It's most of them plus like OpenAI that are dominating the AI space because of the cost of compute. That worries me. And what do we do about that? These laws don't really address that. And then what's the role of private law? We've been talking about public law, that is government passing regulatory laws, but people interact with each other. They interact through contracts. When you use an app on your phone, there's a terms of service. That's a contract. In the US, a lot of the law that governs your relationship with that app provider is based on that contract. It's private law. And then torts. Torts in law is the domain of law that deals with injuries and harms. So, right, that auto accident, that's tort law. We know that area of private law is mostly what governs your typical auto accident. You're not going to get arrested. We don't want that to happen. In a typical auto accident, tort law handles that. How, if in any way, can tort law deal with the harm if AI causes it? It's not going to be easy because the evidence and the doctrines don't map on as much. So this is another piece of the mix that we're all thinking about. All right, so that's my canned thing, and then we'll.
If you have the
Okay. Thank you so much. Sure. Oh, okay.
You turn it on.
Got it. Okay.
Yeah.
Thank you.
Okay, so thank you so much for a wonderful talk. Before we start, basically dive into a couple of questions more deeper. Any question from the audience for our outstanding speaker? Everyone?
Are there any questions against monopolizing such technologies?
Yeah, so the question's about monopolizing the technology, and that goes to this point about the role of those large providers. So if we look back to, I guess I'll use the word more traditional internet or cloud sort of infrastructure, right? So think of search. And we all know Google dominates search. And so there you've got a potential monopoly kind of question. In the US, it's basically, up until very recently, been sort of hands-off. And the idea has been, well, they have a good product. They're good competitors. Other people could compete if they want to be. The law's not going to get involved. In Europe, the antitrust, this is antitrust, is a competition law. The Europe regulators have been very aggressive over the past 20 years against Google and Apple and Amazon. So it's a different philosophy about enforcing that. That's changed a little bit in the US. So it's not clear how that is going to follow with AI. I suspect that in Europe, they'll similarly be aggressive and try and enforce and break up some of that dominance. And in the US, we probably won't. So I don't know. But it's an excellent question. And I think it's a real issue. Yeah. Oh, you had your question too. Good, all right. Yeah.
So more to do with private law, but when an AI generates content, who can claim like the IP or the ownership of that content?
Oh, great question. Yeah, good. So IP, and I do a lot of work on copyright and AI, and so that's what your question. Now, most of what I'm looking at is the inputs, the training data that's being used, that's copyrighted. But we've also been talking about the outputs. About a month ago, the U.S. Copyright Office issued an opinion that said AI-generated content is not copyrightable. Now that's just, that's the Copyright Office. It's not really binding on anybody. So it's not really clear. There are some people who argue that if you're creative in your prompting and you're producing, an image or some text or whatever,
that degree of creativity in your prompting might give you ownership over the output. Although there are others, including the Copyright Office, that say, no, the machine generated that, so nobody owns that. Remains to be seen. Yeah.
When it comes to AI in like a school setting, university setting, do you ever like foresee that eventually there will be laws against it to the point that someone will be prosecuted for even using it?
Like a student using it? I hope not prosecuted criminally. I don't think so. I mean, the way we really, believe it or not, that's actually a domain of private law. So your relationship with your university here, in terms of the academic integrity policies that you might have, and whether a professor lets you use AI or not, right? Things like that, plagiarism, that's all a matter of your agreement with the university. Now, a little different, you're a public university, so there's also a level of public law that goes on that. So I think for the most part, for like university level, it's mostly private law. And even if it's not, it wouldn't be prison, it might be expulsion from the school, right? Yeah, good question.
So in terms of academia or any general platform, people have easy access to LLMs. In my opinion, promoting the use of that, it's kind of hindering the human development in terms of reasoning and logic. So it's more of an ethical thing. So is there any boundary of using that?
Yeah, and so I don't think that's a legal issue. It is a policy issue, right? So, and I think what you're getting at with the question is, and I think about this as an educator with my students, and I'm sure your professors do too. You know, these tools can be really useful. They can do a lot of good things, but you need to learn how to think for yourself. You need to learn how to analyze a text. You need to learn how to write. If you're doing, you know, code, you need to learn how to write your own code before you can make good use of those tools. So I think that's really important, but it's probably not something the law gets into but beyond like sort of private law and policy type things.
I mean, people get used to using that, and it's
Yeah.
kind of adapted. For instance, even in industry also, then it's kind of like a calculator was adapted years ago. Similarly, it may hinder the development, and people may stop being more creative.
It might, but you can also think of, so when I first started practicing law, the older lawyers that I worked for were angry that I was typing my own briefs. Because they were all men, they were all old men who talked into a machine and gave the tape to their secretary, and their secretary typed it out. And I said, well, why should I waste all that time? I type very fast, I think when I type. So some of it is just, you learn, you know, technologies actually shape and enable us to be more creative. It's a balance, I think. Yeah.
You consider AI to be a cognitive agent, and would you see it in the future somehow gaining personhood, like the 1886 Supreme Court ruling with corporations?
Oh, excellent question. So I'll take a couple layers to that. So let me take the philosophical layer. I certainly don't see it now as anything near a cognitive agent. To me, it's a tool. I'm of the school of thought that sort of strong AI or general AI is not philosophically possible. But I could be wrong. I hold that loosely. Some people think it is possible, so I don't know. And I don't think there's many technologists who think we're seriously on the cusp of that right now, although some say that. Now, if that ever does become possible, we have some real interesting questions about what it means for human rights and machine rights and so on. But even if we don't get there, your other question is artificial persons. So you're absolutely right? A corporation is basically an artificial person under the law. It can own property. It has free speech rights. There are legal scholars arguing now that AI agents could and should, in some respects, be treated that way. I'm skeptical, only because I think the corporation already provides those functions, and I still see AI as a tool that a human being or a human corporate entity or whatever is using. I just don't see the reason to give them corporate personhood, but there could be, and there are people arguing for it. Yeah.
Shouldn't there be any law giving authority to customers to decide whether their data is collected in a model or not. For example, you give the casino example. What if the customer does not want any model to be built on his data? Like they don't even want to track their visits and make a simple model on that.
Yeah, great question. And what you're getting at with that question is the intersection of existing privacy law and AI law and governance, right? So existing privacy law under GDPR, for example, in Europe, or in a state in the US like California or New Jersey now that has a comprehensive privacy law, you do have some of those rights as a consumer. So you have it depends on the state in the US, but you have a right to either opt out or they have to give you an opportunity to choose to opt in or not of certain data collection, all right? And you have a right to know what data has been collected, and you have a right to have what has been collected erased and not used anymore. So presumably, that applies to data that's being collected, PII, personal data that's being collected to train an AI. But this is one of those big debates about the OpenAI model, and by I mean business model, right? Because their business model was like Google in the early days, just take it all. I mean, they literally took a lot of their training data from a source called Common Crawl, which is just a mirror of the internet. So there's lots of PII that they've used, and it's not accounted for, and there are lawsuits about that now. So I mean, my sense is the existing privacy laws probably cover this, but there are lots of people talking about, does that need to be more specific and how? And what is your actual remedy? Like, think of OpenAI now. Mostly, if you've ever posted anything on like Reddit or something like that, OpenAI has used that to train their model. What can you do about that? Pretty much nothing. Right? I mean, there's no way they can go back and scrub that. It's now turned into just algorithmic weights that are floating somewhere in a model. So it's a difficult question.
Let me follow up with that question, like the data law. So, like flow, basically river, work for Adobe. Basically, they have the river flow. Basically, like the data just flow by the model, and the model extract all kind of information there, and the data is gone. Basically, like there's no way to trace back, what kind of data is used to train the model, and we don't have a way to determine exactly to prove that, like, okay, so that model has been trained on what kind of data. There's no, you're not like guaranteeing that kind of sense, detection and so on. So like, what can we do about that one? And do we need a new law for data?
Yeah, we might. I mean, that really complicates the privacy question. It also complicates the intellectual property question of training data that is copyrighted and is used to train the AI. Because now, as a legal scholar, I'm kind of in the minority of saying that shouldn't automatically be allowed. Most copyright scholars think that should be just fine. They think it's fair use because they say, well, it's copied for just really briefly, and then it's it's broken into tokens, and then the tokens are broken into model weights. And so what's actually stored in the machine is not the original copyrighted thing, just like your PII is not stored, right? So I mean, my two responses is, well, but you're still making some kind of copy and you're still accessing my PII, at least in the front end. And I'm skeptical. Obviously, technologically, this is how it works, but there are plenty of cases where people, through not too much effort of prompting, have been able to reconstruct at least pieces of things that were used as training data, right? There's a famous example of, I think it was one of the earlier versions of DALL-E, the image generator that was trained using images from Getty Images, which is a stock photography company. And so their public catalog has watermarks. So you're getting images generated by the image generator that has the Getty watermark. It's kind of bizarre, right? Because the watermark is not like stored like, a JPEG or something in the machine, but it's predicting you're going to see this watermark. In the earlier version of ChatGPT, I was playing with it and I said, write something David Opderbeck would write. And it did. It wrote like 3 nice paragraphs talking about law and technology and ethics. And it sounded it wasn't as good as I would have written it, but it wasn't bad. It wasn't bad. And now if you do that, it won't give you anything because they've put restrictions on prompting with individual names. But again, that suggested to me, obviously it used my scholarship that's online and different places as part of the training data. Somehow it was able to predict from just what was in the transformers what I would do. So it's just a new domain. I don't know.
Yeah, so in that case, will definitely affect the following problem is if we put too much regulations, then we hinder the innovations of technology forward, like specifically AI in this domain. Like what kind of framework, what kind of steps that you want to tell us to optimize this kind of like balance? Like the two. We know that from administration, say Europe, that to take off on the regulations if they want to be a leader in AI, or left them off. So
that kind of question's a perennial question with any kind of regulation of any kind of technology. Going back to the beginning of technology and law interacting with each other. And I don't think there's one answer. There's no one answer to it. And there's no way to, I don't believe there's any way to have sort of like a mathematical formula or an algorithm. Maybe we can ask ChatGPT about this, right? An algorithm that would tell us, here's the best way to do this. We have to make some judgments. Now, again, my colleagues on the intellectual property side who are convinced that we shouldn't let copyright be a barrier to access to training data. They're thinking, I think, like we were thinking back in 1993 about the internet. We were saying the same things. We don't want copyright to sort of be a problem for people getting access to information on the internet. It was a good sentiment. But at the time, nobody was anticipating this dominance of some companies and social media and the distortions that would arise, right? So my kind of response is, I don't mind if the law actually puts some brakes on the way the technology is being sort of developed and deployed. It's a phenomenally important technology. It's going to have incredible benefits, but it has these huge risks. So I'm okay personally with slowing it down a little bit. Others aren't. That's a judgment call.
I see. Thank you. One more questions? Yes.
Well, I want to ask a question related to IP. It's a follow-up question. I think what you mentioned just now are two extreme cases. One is use generative AI. It's a human intervention is just 1%, like approximately 1%, by giving a prompt. And then all the remaining work is done by AI. And on the other extreme, if I use or digital pen,
right,
I have the copyright because if we call it AI or a certain intelligence, I'm contributing 99%, and this digital pen is only 1%. However, if one day that is half-half, how to define the IP? Because currently, generative AI does not allow a huge human intervention. That is a model issue. We use diffusion or VAE, whatever. We don't allow much human intervention. But in the future, if we can develop a model to allow, say, 50% of human intervention, then the contribution is 50% from human, 50% from generative AI. How to define this IP?
Yeah, I agree with your sentiment there, and I'm not that persuaded by the Copyright Office's blanket opinion that nothing produced by generative AI could be subject to copyright. And the example, actually, that was the core example in front of the Copyright Office was, this piece of art. I don't have an image of it with me, but a piece of art that somebody made, and the person said they spent like 3 full days refining their prompts to get exactly the image they wanted. That seems to me pretty creative, right? That seems to me enough. And so I'm not, some point there's a line. I'm not sure what it is. And even you're talking about Photoshop. I mean, so many of the tools in Photoshop are now powered by AI, whether that's real or not. But still, right? Where do you draw that line? I'm not sure. But I think a blanket banning is not a good idea, and we probably will come to some other kind of balance about it, I guess.
Okay.
So I have, could you expand on your thoughts on the comprehensive regulations versus sectorial ones? What kind of situation would we want, like, do you have an example of something where we want to regulate the underlying technology itself versus if you're thinking of AI as a tool, then we just regulate where we use the tool.
Right. Yeah, I'm not sure I have a firm opinion about this on AI yet. I have a firm opinion about it on privacy. I think the comprehensive approach works much better for privacy than the sectorial approach because it's centralized. Businesses know what they need to do across any domain they might be. So, like, if you're producing a health tracking app, does HIPAA apply to you or not? You have to do. You don't have to worry about that if you have a comprehensive approach. That, to me, makes a lot of sense. And I think the interests of privacy, the public policy interests, are so important that it's worth doing. I don't know. Part of the problem is it's so hard to define what we mean by AI. It might be too hard to have comprehensive. So I'm up in the air on how that applies to AI. Good question.
Okay, thank you. I think we run out of time. Thank you so much for.
Thank you, everyone. And I'm just down the road at Seton Hall, so at the law school. So if you folks have questions or interested in stuff, shoot me a note.
Thank you.
Good.
Yes.